Welcome, Rod Koenig, to the Legacy Lounge today. We're very excited about you being here.
I am honored to be in the Legacy Lounge, and that's very apropos to the areas we work in.
And what we'd like to talk about and learn more from you today. There's such an incredible heritage that you bring to the estate planning community. 55 years at Fulbright, Norton
Rose Fulbright these days.
Thank you, Rod. Yes,
but many folks remember us as Fulbright Jaworski.
Fulbright Jaworski, yes. But a retired partner, but of counsel.
Of counsel means I still go to work every day.
You
just don't get paid
do.
Quite as much. So.
Well, and 55 years.
Right.
There. But not only are you incredible in the firm, but your outreach in the community is amazing. You're on 23 boards. You are on 5 grant foundations. And you've been really active in the Navy with areas such as Battleship Texas.
And the battleship just was refloated earlier this week.
So it's actually
working.
In,
it's been in dry dock.
Okay.
In Galveston, and it was refloated. It floated from the dry dock, and they took it around the corner to another pier there. I spent about 10 years on the Battleship Texas Commission. Governor Clements had appointed me and others to, and we, quote, ran the battleship, if you can believe that.
Exciting.
But we were involved in that for a number of years.
And that's really flowing out of your Navy background.
Right.
Right?
You must know, I live on Annapolis and University, so I live and breathe Navy.
That was intentional, I'm sure.
Not quite, but I was very pleased that it worked out that way.
But you bring so much richness to the community, and you're active in the choir.
We are, my wife and I sing in several choirs, and last night I played trumpet with a brass band. I do that weekly. And we're involved. Used to be president of Houston Early Music and on the Bach Society board and on Festival Hills board up in Round Top. Wonderful area.
Amazing.
So we love music. We love music.
And you've given back to the community, not just in time and energy, but also you've encouraged people to give back. And we'll want to talk about that a little bit today. And you still manage to fit in some estate planning.
I do.
As an attorney.
I get a paycheck.
And exciting work you do. The whole topic, estate planning, death and dying. Sometimes it's hard for people to approach.
It is. Most of us really don't plan to die. I don't plan to die, but I suspect statistically I'll be one of those folks. I had an Uncle Charlie that lived almost to 103.
Wow.
And so my goal is to beat Uncle Charlie. And
Sounds
so
like a
if
good
I make
plan.
104, I'll be hopefully have the marbles left to grin about that. So
yeah. And you speak about it fairly openly, but I think a lot of people really avoid the topic and even put off doing their wills.
Oh, they do.
Why do you think that's the case?
Dying, ending our existence on this earth is something in many cultures it's taboo to talk about it at all. I think we're a lot more open. If we're realistic at all, we know that we have a finite amount of time here on this earth, and all of us manage to accumulate assets, family, friends, institutions that we like and want to support, and so ultimately the car I drove up here is going to go to someone else. I'm not going to be able to drive it in the little cemetery that I'm president of up in the country.
You can't take it with you.
Can't take it with me. Okay. And nor can any of our clients and our friends. So,
do you think it's fear of the unknown also?
Probably. That, and none of us have experienced death firsthand. And so when it happens, maybe we'll be surprised. Those of us who believe in a supreme being hope that it will continue in another dimension.
And even be greater on the other side.
And hopefully it'll be greater on the other side. But in any event, we don't need to do anything. If we do absolutely nothing, typically the law in Texas or wherever we happen to live will determine where our property goes. But in my mind, it's better to be proactive and be involved and know that my farm may well go to my children. I sort of would like that.
Yeah. Yeah. So for all that you've worked your lifetime to build, you'd like to be able to determine who gets it, when they get it, and what they get.
Right.
And so a lot of people put that off, though, and it's interesting. The question, I guess, is, how do you motivate people to get started? Because it is tough, and sometimes it's very complex. You talk in with respect to a lot of terms that are confusing.
I recall a very elderly gentleman coming to my office. It's probably been 30 years ago. You've probably heard of ninfas on navigation.
Sure.
This gentleman was in his middle 90s when he came in, and I knew that he was coming in to look at his planning. And I said, could you give me a copy of your current will? If I recall properly, he was 95. He said, haven't needed one. I haven't needed one yet. I said, well, I understand.
Spoken you're still like an entrepreneur.
You're smiling and you're perky, but don't you think it may be getting close to time? And he said, well, yes. And the main reason I came in, our family, my grandfather, owned this land right behind Ninfas on Navigation. I've been handling that for the family for the last 40 years or
Wow.
however long, and I really need to do something about that, because if I'm gone, there are a lot of folks in my family. We followed up on that, and there were 40 some odd people who owned an interest in this vacant lot,
Wow.
which took a while. We found several that had gone to Mexico, maybe in a drug deal, maybe not, who knows.
Who knows?
But we ended up selling that vacant lot. He did, along with all of the heirs we could find. We couldn't find all of them. There were maybe 5 or 6 that were never located, but Ninfas was willing to buy it anyway. And I think when you go down to Ninfas, there's a parking lot that they have about 85% legally, and the rest they've probably claimed by adverse possession. So.
Interesting.
But the point was, this elderly guy, 95 if I'm right, said, I don't need a will. I hadn't needed one yet.
Right.
But before he left, we did decide, and he in fact signed a new will in his own. And we hopefully solved the problem with the family lot behind this old restaurant on Navigation.
Well, a lot of people are also afraid of probate. They hear the term probate and they're fearful.
One of my partners, Charles Saunders, who, bless his soul, has been gone a while, Charles wrote the first book called How to Live and Die with Texas Probate. I was a young baby lawyer at the time, and I wrote one of the chapters. I think I wrote the
wow.
chapter on living trusts, but probate actually is not that bad in Texas. There are several states.
What is probate?
Okay, good question. Probate. Basically, Deborah, if you kick the bucket, that's a technical term for dying. If you kick the bucket, someone's got to drive your car home. Someone is going to have to get the keys to your home. Someone is going to have to decide what happens to legacy room that we're sitting in. And probate basically does several things. It is the process of transferring assets when one dies. It's the process of paying debts. You're probably one of the few exceptions, but some of us have debt. I mean, I have my monthly electric, telephone,
Right.
computer, you name it, bill. And most of us have bills of some sort, may not be huge, but some of them are huge. And so we need to pay the debts. The probate process helps ensure that your creditors are taken care of. It also gives Uncle Sam, and in some cases the state of Texas and other governmental agencies, the right to get one last tax. And so probate process in the broad sense means who's going to get my stuff? Who's going to drive my car home? Who's going to pay my last phone and electric bill? Who's going to pay off the mortgage? And who's going to pay Uncle Sam on the estate tax or whatever tax is due and owing? There's a separate, we could do a complete new lecture on tax. There are a lot of taxes. There's even a beer tax and a fur tax and a computer tax and a sales tax and a franchise tax.
Lots of taxes, but
Lots
at
of
death.
taxes. And if you die, there is an estate tax, U.S. estate tax, if we live or are green card holders or have assets in the United States. If you live across the border in Canada, the Canadians have a capital gains tax at death. But there are taxes in almost every jurisdiction. Is tax bad? Not necessarily. I drove here on a nice freeway, and I drove up on a very lovely street, and we have a lot of amenities that we need to have, and guess how they get paid for? Largely through taxes. So I'm not opposed to tax. I just don't want to pay more than my fair share.
Good point.
Anyway,
Are there some assets that don't go through probate?
Absolutely. When I use the term probate in a very broad sense, I'm talking about everything, whether it's, quote, a probate asset or a non-probate asset. Probate assets are ones that, if you have a will, are controlled by the will. Debbie has a will that says, I leave my husband Monty X, and I leave my kids Chelsea and Andrew Y, and I leave my favorite charity Z. The will take care of that sort of thing. There are a number of assets that are not controlled by the will. I love to think of those types as having little mini wills. For example, my pension plan, my IRA, I have a beneficiary designation that I can say, I leave my IRA to my wife Mary, or to my kids, or to my grandkids. The will control items that are not controlled by those little mini wills, like a beneficiary designation on life insurance, beneficiary designation on IRAs or pension plans.
So what supersedes in the probate process?
In the probate process,
If a beneficiary designation or the will?
typically the beneficiary designation will control. So, quote, if you want to avoid probate in the stricter sense, then you have your life insurance beneficiary designate a person or a trust or a charity or what have you. And the same is true of, and there are a number of ways you can handle things in a non-probate sense. For example, many of us have bank accounts. The bank accounts may be solely in our own name. If they're only in Rod Koenig's name, then when I die, who's going to get it? It is a probate asset in that sense, and my will decide who gets that. If my bank account is a joint tenants with right of survivorship with one of my sons or one of my grandkids, then the first one of us to die, the survivor will automatically get that account. That is a, quote, non-probate asset. Many times people have huge amounts of assets as non-probate assets, and there's nothing wrong with that at all. But it sometimes complicates planning if the estate is a taxable estate.
And you could be sending different signals. For example, you could say in your will, my spouse gets everything. But if there's a bank account, a life insurance policy, a trust out there, it could create some conflict.
It absolutely could. Thinking a
Do
little...
you see that much in your practice?
Sure. Many folks believe once they've done a will that it'll control everything, and it will not. For example, don't get mad, Deborah, but, and will my wife hear this?
No. Will.
Good. No, that's
Not today.
Not today. Sometimes folks who have a girlfriend or a boyfriend on the side handle that with a, quote, non-probate asset. So there may be a life insurance policy or some non-probate asset that goes to this paramour. I'm not advocating that. That's
I understand.
the source of many will contests and fights, etc. I wonder why.
Because there are a lot of things that can travel to people outside
of
will.
a will, exactly.
Yeah. Okay.
And so basically, if the estate is large enough to be taxable, and that's a whole separate issue, today, as of
Yeah, let's
what's
talk about
the
that.
date today? March
It is March
7th?
7th.
March 7th,
2023?
2024.
24. Good, Deb.
You and I can each have 13 million, I think it's $610,000, and there's no federal estate tax on that, assuming we have not made significant gifts in the past. So basically, that threshold is fairly high, and yet, if we look at your clients, my clients, a number of them have homes that are easily worth more than $1 million.
Right.
They have pension plans or IRAs that are worth significant amounts. They may have a closely held business that's worth megabucks. They may have inheritances that have come from grandpa or
Well, good point, because I think there are a lot of people that think that there are assets that don't go through probate and therefore they're not subject to estate tax.
wrong.
Okay. So what
Wrong.
is there anything that's not included in the estate?
Absolutely. In my estate, things that you, Deborah, own are not in my estate. So it's stuff that I own or that I control, and that means things like life insurance that I still control is in my estate. If I have a $5 million life insurance policy, it counts toward the $13,610,000 exemption. There are easy ways to get assets like that outside of our taxable estate, but typically anything that we own directly, think your house, think your car,
Stocks, bonds, real
bonds,
estate,
right, bank accounts,
a business.
a business,
You have to
artwork.
tally it.
We're in the legacy room, and I see some very interesting art. It's probably not worth much. It's probably worth a bunch. And so that artwork would need to be valued if you're the person who owns that, or if I'm the person who owns it.
So there's nothing really that, unless you go to great lengths to establish trusts outside your estate, consider everything you own to be taxable.
Yes, yes.
And we've got this exemption that's very generous that you were talking about.
It's $13,610,000. That means you're married, I'm married, my wife and I, your husband and you, each have a $27 million exemption. That covers a lot of folks.
It really does.
And that means a significant number of the population are not even interested in estate taxes. May be interested.
Do you think because the exemption has been so generous that people have become complacent about estate planning?
Absolutely. And for some, I recall years ago, I had a cousin, good gentleman, but didn't have a lot of assets. I think he was extremely concerned about setting up trusts and avoiding probate and avoiding estate tax. I think his total estate was $250,000. And that's when the threshold was $400,000.
Right.
And I said, it's okay. You're going to be absolutely fine. However, if you win the lottery, you should have had a lottery trust. And I jokingly.
No, but
although I do have a lottery trust. It's a.
You really do?
I really do.
Is that one of the more interesting cases in estate planning that you have worked on?
Yes, it is. I recall years ago I had 3 City of Houston employees working for Metro. They were mechanics for Metro, and they fixed the buses that people ride. Well, one of my law partners knew that I dabbled in the lottery area. I've even written some articles about how to send your kids to college. 1, use 529 plans. 2, win the lottery.
Right.
Winning the lottery is a little more problematical. The odds are not real high.
Probability is low on that one.
But these particular mechanics came in because they knew that I dabbled in that area. They had won a $13 million lottery at a time when the threshold was maybe $1 million.
Wow.
And I said, you guys are so lucky. You've won a $13 million lottery, and each one of the 3 of you is going to have $70,000 a year for life. They said, no, we won a $13 million lottery. I said, you're right. You're going to have $70,000 a year for life. And they had this quizzical look. And I said, well, but we won 13. Why do you keep talking about 70,000? I said, number one, it is subject to income tax. You're going to lose, at that point, the income tax was at 50%.
Wow.
You're going to lose half of it to income tax.
Mm-hmm.
And number one, losing half to income tax is one thing. Secondly, there are 3 of you. You're going to cut that in a third. And then thirdly, you're going to have to invest that. And if you invest that, you're going to have $70,000 a year for each one of the 3 of you. So don't give everybody at the office or every relative $500,000 because you're not going to have that.
That's that sudden wealth syndrome.
Exactly.
And people
But
do
most
need
of
guidance
us,
there.
But as a result of that, I said, what if I won the lottery? And so I created a lottery trust. My first trustee was Rick Rambo. I did that on purpose. He was one of our young lawyers at the time.
Oh, that's funny.
And then I flipped it to a bank if I really won. And I called it the Blackjack LA Trust. Blackjack Springs is where I was born. Los Angeles is where my wife was born. And so I have the Blackjack LA Lottery Trust. When I buy a lottery ticket, I normally buy it at a gas station. Where do you buy your lottery ticket?
I'm not a big lottery ticket purchaser, Rod.
That's why you have more money than I do. I do this when the odds get really bad against me. I'll buy one when it's at $1 billion or something.
Oh, that's funny. So
But-
you've got it out there. You haven't had to
Oh.
use it yet.
Haven't had to use it.
But it's
when
out
I
there.
buy gasoline, I think the IRS, but part of my plan on the lottery trust, I will buy a ticket and I'll give half of the ticket away. So that if I win, I still get to keep something that I can friddle away.
Without it being subject to estate tax.
Without being subject to income or estate tax.
Income or estate.
And
Okay,
but
great.
my kids and grandkids and relatives and charities I love are all beneficiaries of my lottery trust. And if I win, they're going to have to pay income tax on their half. And so
Well-
anyway, it's a fun thing.
That is fun.
I don't hold my breath. I'm probably never going to win. But the IRS would probably contest that lottery trust. And so I always put my transfer of half of the ticket on the back of a gas slip that's time dated.
Oh,
So anyway,
interesting.
it's a
The
a
lottery
lark,
trust.
but it's fun to talk about.
Yeah.
And in fact, I wrote an article that was published about winning the lottery and using
I'll
a
have
quote
to look
lottery
that one
trust.
up. A lot of people who begin their estate planning are curious about trusts. And there are so many different types of trusts.
There are
Can you
indeed.
speak to first revocable trusts?
Sure. I
and
will
then
say
we'll
immediately.
move on to irrevocable.
The lottery trust that I created was not revocable. It was one that was irrevocable, and I'll get into the reason
Great,
later.
great.
Many folks who, quote, want to avoid probate, one of the ways to avoid probate is to create a living, revocable living trust and then put everything you own in that trust. And hence, when you die, you don't own anything directly. You own it through a revocable trust. Revocable means I can change my mind. You could change your mind and take it all back the next day. Or you could change the trustee, or you could change the beneficiaries, et cetera. And so
It's
many
completely
folks,
changeable, amendable.
absolutely. and absolutely includable in your taxable estate.
So no estate tax benefit.
There's no estate
from the
tax
revocable
benefit,
trust.
no income tax benefit
Yep,
from that.
just to pass through.
In order to get to that point, it would have to be irrevocable, can't change your mind type of trust.
So if probate is not that big of a deal in Texas, and as long as you get your mini will straightened out, are you seeing many reasons for revocable trusts in Texas?
Sure, and I'm going to, without using names, I'm going to use an example that I met with a lady I met with earlier this week. Years ago, she and her husband created a revocable trust. They were in their 80s at that time. She is almost 100 now, and since then her husband has died. But we created, because of their age, in their 80s, we knew that there was a chance they might become incompetent. They may lose their marbles. Neither did. I mean, there's this lady who's almost 100 is still very much has her marbles, but they created a revocable trust and put their home in it, put stocks and bonds in it, put almost all of their assets in that trust. And when her husband passed away, and he did a number of years ago now, we created a tax-oriented bypass trust as part of that arrangement, which then became irrevocable as to that half. And any event, that revocable trust, things that were in that, the trustee handled it. And in that case, the revocable trust had both husband and wife as trustees. And they managed it as long as both were alive. When her husband died, she continued to manage that trust. At that point, she could change her half. She couldn't change her husband's half. Mm-hmm. His half was isolated from estate tax, and we had a tax fence effectively built to separate his half from her half.
So when you do a revocable trust, you're transferring title, and you talked about probate being transferring title. So isn't a revocable trust a little bit like doing your probate while you're alive?
Exactly. And most people, I tell folks, if we do a revocable trust, and if you do not transfer assets into that revocable trust, you haven't avoided probate on those assets. Right. And so I have often done revocable trusts and something I call a pour-over will, so that when someone dies, what hasn't been transferred to the revocable trust is then transferred, but that portion is transferred through the probate process. And so depending on how anxious people are to do this, mm-hmm. and it's going to take time and effort to transfer assets. Mm-hmm. For example, the almost 100-year-old lady I spoke of, they in fact had to pay for deeds to their home to be transferred. They had to work with the brokerage houses on their stocks and bonds. So they effectively went through the transfer process during their lifetime. Some people don't like that, some do. The cost may be almost equivalent, and because it's done while you're alive, that's fine, but it's going to take some lawyer, someone time to transfer those assets. Mm-hmm. Some of it you can do yourself and right. Work with your brokerage house or your financial advisor, etc. Mm-hmm. But if you don't transfer everything, reminds me of another matter I had years ago with a very influential financial advisor who asked that I help in that regard with his parents, and we did. We created a revocable trust, transferred every asset they could think of into the revocable trust, and while that was happening, I said, and now we really should do what I call a pour-over will, just in case you forgot something. What would we forget? I can't tell you how many times Grandpa Jones owned an interest in East Texas, and there were minerals there. Mm-hmm. And the minerals weren't producing, and the family sort of forgot about those minerals. And then after they transferred a lot of things to the revocable trust, someone dies, and then guess what? There's a discovery, an oil field in that part of East Texas, and they have 1,000 acres of royalty interest that weren't transferred anywhere. What do you do with that? If there's not a will to transfer it somewhere, hopefully to the same trust, you're gonna have died without a will as to that particular
as to that
asset.
asset. Incredible.
And so, any of the case I was talking about had an equivalent. It wasn't oil interest, it was a municipal bond that Grandma had purchased and put in the desk drawer, lower left drawer, and it was sitting there, and they found it 6 months after she died.
Wow.
And guess what? The transfer agent wouldn't transfer that bond just because there was a trust sitting out there. Someone needed to say,
So
who
it's
does
as
this
if
go
you
to?
died intestate or
As
without a
to
will.
that particular
as
asset.
to that asset. And
Right.
it's easy to accumulate so many small things over time.
I recall years ago, I met Bunker Hunt. He didn't know me, but I met him at a function at the Houstonian. And I remember he said, if you know what you own, you're not worth much.
Oh, that's a great line.
Because a lot of
that
folks,
was apropos for
a
him.
lot of folks particularly folks with significant assets, will have forgotten about assets they bought into, maybe this small, closely held business
A long
that they
time
were helping a
ago.
friend with that they
Interesting.
still own 1,000 shares of that they've forgotten about. Maybe it's the next Microsoft or NVIDIA or what have you.
Yep. But doing a revocable trust is a benefit even to your heirs, especially when you have the pour over will, because then a lot of the work in transferring title has been done.
It's been done, but there's an even bigger benefit in my mind
Okay.
for elderly folks. My almost 100-year-old lady that was working on with earlier this week, we have a revocable trust. That trust has a feature that flip it to a bank to help run the trust. While she still is very competent, she can have someone help her in her old age in case she loses her capacity. And so that's something most of us, we are going to die. We don't like to admit that, but we will. There's a high probability that in the later years we may lose our capacity. My Uncle Charlie lived to be almost 103, and he was clear-minded to 102. His last 6 months, he was not clear-minded.
So
And-
end of life.
End of life,
You've named your successor in terms
and you
of
have someone
managing,
that can help pay your
that
bills.
can step in, pay
and-
your
and
bills.
help in that regard. So that, in my mind, particularly for elderly folks, is a very big advantage
Yeah, I
of
think
having
we'll see
the
more of
revocable
that.
trust.
More of that, don't you?
Right.
Now, irrevocable or irrevocable, people say it different ways, but what are the benefits? And a lot of people will say, well, I'd rather just give it outright to my kids. You know, why do I need to complicate things with a trust? So they can both, while they're alive, they can make transfers during life, they can make transfers at death. What's the benefit to making those in trust rather than outright?
In trust, there are, as you said earlier, there are any number of kinds of trusts. I just mentioned the lottery trust. There probably aren't but 10 of those out there, period. Blind trusts for politicians. We're in election mode, and we've done blind trusts for people who are, there are separate ethics rules for the judiciary, there are separate rules for the legislature, there are separate rules for federal officials. Blind trusts, those are a separate issue. There are things like life insurance trusts. We can have trusts that literally own a separate asset. There are personal residence trusts that are available. There are charitable lead and charitable remainder trusts that have to do with charities. There are foundations that are trusts. The irrevocable trust is one that, because it is irrevocable, I can't change my mind about what I've done. It is permanent from a tax viewpoint. And hence, if we focus on just one of those, like a life insurance trust, if I own life insurance, and I do, on my life, if I control it myself, I still have some small Navy mutual aid life insurance life insurance. They're not huge, and so I've not given them away to anyone. I can change my mind, but those small policies will be in my estate when I die.
So they will inflate your estate
They will
because they were
inflate-
assets you didn't have,
Exactly.
but they blossom
into
the
full
death benefit,
value
into
at
full
that point.
value.
If, however, I took a policy and put it into an irrevocable trust that hopefully, typically would benefit my family the same as my will would benefit the family, I would have a parallel universe with that life insurance trust benefiting essentially the same folks I want to, but I make it irrevocable so that if I get mad at my son, I can't cut him out of that one. I'm not going to get mad at my son. He may tick me off, but the odds are high he won't. And if he does, shame on him and me both. But I might be able to save 40% of that value. Currently, the federal estate tax top bracket is 40%. And so if I had $1 million policy that I own directly, 400,000 of that, if it's taxable, is going to go away that Uncle Sam will get.
In the estate tax.
In the estate tax.
And some people confuse the income and estate tax treatment of life insurance.
Right.
Life insurance is always income tax free.
Not always, but
Well,
mostly.
most, thank you. Yeah, because there's always an exception. But a lot of people think that they hear tax free and they think estate tax free as well.
Exactly. Typically, as you said, life insurance proceeds are income tax free. Income tax is a big ticket item. That's what we pay every year and have for all of our working lives and beyond into our retirement years. The estate tax is a one-shot tax, and guess what? I'm never going to know what estate tax my estate pays because I'm going to be dead. But when it hits, if it hits, it's a big tax, 40% currently. It's been as high as 90%. I think when Howard Hughes died, it was in the high 70% for folks above a fairly low threshold. As we said a little earlier, the threshold today, 2024, is at 13,610,000. So a lot of folks won't have to pay an estate tax.
But anything above that,
Anything above that, it's 40%,
40
40 cents on
each
the dollar. And so we were talking about irrevocable. If I have a revocable trust, whatever is in that revocable one that I can change my mind about will be in my taxable estate. If I have one that is irrevocable and I've given that away, and there's some timing issues on that as well, depending on assets.
thank you. That clarifies it though, because a lot of people don't recognize that you can avoid both the income and the estate tax.
Right.
If it's out of your
If
estate.
it's out of the estate.
And if it's an insurance in a trust.
And you're aware of modified endowment policies in which you
Right.
could pay income tax, but that's highly unusual and that's a very small percentage.
Yeah. When we're talking about trusts, beyond taxes, which, by the way, can you speak a little bit to estate taxes, when they're due, how they're paid?
Sure. Estate tax becomes due 9 months after date of death. So
Okay.
today is March 7th, 2024. March, April, May, June, July, August, September, October, November, December. If I died today,
Merry Christmas.
not Merry
That's when the
Christmas,
tip-
Happy Pearl Harbor Day.
Oh.
9 months from today would be Pearl Harbor
Day. You're right.
And so it would be a Pearl Harbor Day for anyone who died with an estate above the threshold. Now, there are a lot of exceptions even there. And I do love my wife. If Mary hears this, and if I leave assets directly to my wife, there is something called an unlimited marital deduction.
Thank you.
So
So no estate tax.
no estate
At the
tax,
death of the first in a couple.
and that's for a United States citizen spouse.
Yes, not true for
Not
a
true.
non-U.S.
And
citizen.
it's not true for non-citizens, non-resident, green card holders can get a marital deduction, but there's a whole separate set of trusts that must be used, the Q dots, in that
Right.
regard, and that's a separate
Okay.
topic for folks who are green card holders.
But generally,
Generally,
everything you own is going to be taxed. Everything above the exemption
right,
at 40 cents
on the
on
dollar.
the dollar.
And the payment on that is due 9 months after date of death. And so that raises a question of what did we use to pay for it? Guess what? We're in the legacy room. Can't use those paintings to pay.
Are you sure?
I'm sure.
Okay.
But guess what else? If you were in France, I think it's France, maybe it was Spain, Picasso, I think, paid his death duties, or his estate did, with paintings.
Well, that
Some
was
jurisdictions,
Picasso.
some jurisdictions allow you to pay it with stuff, with things. Not
Not-
true in the U.S.
Absolutely true, right? In the U.S.
In the U.S., you need to raise cash to pay the tax. And that brings me to a different issue that many of my major clients have, and that is, how do you pay? Can't use those paintings, can't use the Brenham farm, can't use that closely held business.
Or you could, but you'd have to sell those assets
You
within
need
that
to pay with
9 month.
cash. You
They
need
don't
to
want
pay
your
with cash.
Brenham farm. They don't want your real
Well, they
estate.
might want it, but they can't, they won't take it as payment.
They won't take it as
Now,
payment.
you can go to your
Yeah.
local banker and hope you can get a loan. You can use something called 6166, which is an Internal Revenue Code section that says if a certain portion of your estate is in a closely held business, then you can ask for and get an extension and get some pretty favorable interest rates on part of that. But you still have to pay.
So you borrow the money, pay it off within that 9 months, and then you have an open commitment to
Right.
pay.
Or you can also do what a lot of my clients have done. You figure out what you think the estate tax will be, and you get in. If you're young enough and healthy enough and have enough cash flow, you can buy life insurance that hopefully you'll squirrel into a life insurance trust, or have your kids or grandkids own that directly. A little bit of an issue with the kids or grandkids owning it. Life insurance, the kind you would use for this, typically has cash value. And I have known children to borrow that cash value and cause the policy to lapse after a while.
Right.
So I typically say the kids can own it, the grandkids can own it, a spouse can own it. But I typically lean toward, if you're going to need the monies to pay estate tax, to have a life insurance trust own that policy.
And how do those
And it would
premiums,
be irrevocable.
and irrevocable to get the estate tax benefit. How are those premiums paid for that insurance?
Somebody's got to raise the money to pay the premiums. And life insurance is not necessarily cheap, although it's economical compared to having to raise money in 9 months. Typically the way they're paid, grandpa or grandma or mama or papa typically will gift the money. And the gift tax currently, you and I, everybody in the U.S. has an $18,000 this year in 2024. We have an $18,000 annual exclusion from the gift tax.
And that's a renewable annual
Every
exclusion
year.
every year.
We had a
right?
$17,000 free gift tax last year. And those are indexed for inflation. It went up from 17 last year to 18,000 this year. That means Mama could give an 18,000, Papa could have an 18,000. That means a married couple could give 36,000 to everybody on the face of the earth. We could go broke making non-taxable gifts, annual gifts. Most of us won't make those gifts to everybody. Some of us are biased toward our kids, grandkids. If they're good, we might even think about spouses of children. And it occurs to me that if you have 2 children, or 2.1, whatever the average number, if let's say you had 2 children, and at least one of those was productive and had 3 grandchildren. So if you had 2 children, 3 grandchildren, and you liked the spouses just a little bit, that you had 2 more spouses of children, that would be, what's that, 2, 4, and 3 is 7. If you had 7 total people you could make annual gifts to, if you multiply 7 times the 36,000, you get $250,000. You actually get $252,000 that you can give away every year tax-free. Most of us don't have $252,000 ready to write checks. Some of us have enough. We pay college fees for grandchildren.
Right.
But particularly if you're in the taxable area, the odds are high you're going to have some significant funds.
But that's $250,000 that you could give away every year.
Every year, forever and ever.
Forever and ever.
And if you don't use it this year, you can't go back and claim it for last year. So
Right,
it's
so
a
use
use
it
it
or
or lose it type
proposition.
And particularly when I have clients that are close to the threshold or way above the threshold, I say this is a freebie. This is something you should do every year. And not only the 18,000 a year to every person that you feel close to. I remember having a family with like 20 grandchildren. We moved several million a year, or could move a lot of money every year.
Every year.
And we did. And I nipped at them. And in addition to just moving it, there are ways you can move it for medical expenses and education expenses that are over and above.
Paying those directly.
Yes, you could pay those directly to the university or to the medical provider or what have you.
I remember Stephen Leimberg, who just died fairly recently, calling the annual gift exclusion a little giant.
Oh, it
because,
is.
Used one time for one beneficiary,
It's not a big
it's
deal.
not material. But used like in the way you're talking about it, and used
Every
every
year.
year.
And do it
powerful.
systematically.
Yep.
And the nice thing about that, you can make the gift this year, and if you have that ungrateful grandchild that doesn't come home for Thanksgiving or Christmas, cut them out next
Just
year.
cut them out next year. It's funny.
But typically, we're not going to do that. Hopefully, even when you get mad at your kids or grandkids, I typically tell folks, they'll get over it, you'll get over it, let's look beyond it. If they don't come for 5 years, then maybe you should
That's
cut
a
them out.
different
But I
story.
don't think, typically, my advice would normally be, they're your kids, they're your grandkids, take care of them.
Right.
And beside, how many houses can you own and how many cars can you drive? If you get to a certain point, you probably should be moving stuff over to the next generation.
Yeah, and that's not an easy decision for people. They clearly sometimes, don't want to create trust fund babies or
And that's a
destroy
good
incentive.
point. That's a good point. I bump into clients sometimes who do have trust fund babies that I think Warren Buffett probably said it the best. You may have, years ago, he had an article in Forbes magazine, and he said, I'm going to give most of my money to charity. And in fact, you recall that he and Bill Gates combined, and they did, in fact, move a lot. And Buffett said, I'm only going to give my kids $100 million each so that they can do
Only.
anything. Only 100. I said, I could do nothing on a lot less than 100 million.
Right.
But
He
any
was in a
event,
special situation.
yeah.
So if we look at estate taxes, we know that people are generally putting this off. But there are some reasons, especially in the next couple of years, why people might need to get more serious
Right.
about estate tax planning.
I think many folks don't know this, but generally we've been under a regime that says that the estate tax currently, as I said, the threshold is $13,610,000 per person, 27 million plus for a couple. That's been indexed for inflation. It will go up in 2025 again. We don't know exactly to what, but it's going up. But December 31, 2025, that ends. And it will revert on January 1, 2026 back to 5 million as the threshold. That threshold is indexed for inflation back to, I think it's 2010. Don't hold me to that, but it goes back and it's indexed for inflation. Most of us believe that means that by January 1, 2026, the threshold will be in the 7 million plus range. If that's true.
For an individual.
Per individual. If that's true, and it will happen unless Congress changes it. So we are looking within the next year and 9 months, that threshold of 13.6 will drop down to probably near 7 million. However, if you make a major gift now, between now and that number, there are rulings out that say that'll stick. So if, let's say you had a...
Some people are concerned with a clawback on
Right,
that.
but that won't happen. There's some regs
Okay.
out that say the clawback won't happen.
Okay,
But
great.
that was a major
But you
worry.
could forfeit the opportunity to
If
do
you
that
don't do it, it's
if
a
you
use
don't
it or lose it type
within
of
this
thing.
window.
Right.
Okay.
And so
Do you think that it will happen automatically? It's the path of least resistance is to just let a law that's already written and agreed upon.
we know that Congress, both the Senate and the House, are very active and always get things passed. I say that tongue in cheek, although I think I read something that maybe they will get off the fence here shortly on several items, but we know what the law is currently. It will drop unless Congress changes it. The odds of Congress changing it, who knows? We will have an election this fall. We likely will have a new Senate and likely have a new Congress. We may or may not have a new president. But things will change. Whether or not, even in a new Congress, there'll be legislation changing this, who knows? I don't know. I do know that the current law says the threshold will drop back to the 5 million as adjusted, which is probably 7 million plus.
So it is a window of opportunity
It
to
is.
capture what you can.
And
now.
if someone is well over, because it's going to be around 7 or maybe even 7.5, that's
individual.
14, 15 million for a couple. Anyone whose estate is above that may want to think about moving maybe a significant amount over before January 1, 26. And I will speak for our firm. As we get closer to the end of 2025, there are going to be a lot of work going on, and you may have trouble finding board certified estate planning folks who are able to help.
You anticipated my next question because this is a very specialized part of the law, and there is not a huge oversupply. In fact, in many ways, the number of certified estate planning attorneys are undersupplied for the demand. Don't you think?
I think so, but I'm biased in that regard. So you need to.
But there are people out there thinking, well, if I've got a year and 9 months,
I'll wait for a year and 8 months.
I'll wait for a year and 8. And what would
and
your advice there be?
If you start thinking about it now and get with it, let's get something done sooner rather than later.
Great.
Sooner rather than later.
Great.
And then there'll be some folks that'll be able to help. And the use it or lose it annual exclusion is something that everyone ought to think about.
On an ongoing basis.
On an ongoing basis. And the once in a lifetime between now and January 1, 2026 is an important one to consider as well.
Well, Rod, this is an area that is immense, and we could go in many ways, but you have really covered a lot today. Is there anything that I should have asked you that I didn't?
Sure. What happens if you die without a will completely?
Let's do it.
If you died without a will, your heirs would inherit. Who are your heirs? Are you married? That's one of them, that spouse. Do you have kids? Those are heirs. Have you been married before? Do you have kids by a prior spouse? All of a sudden those heirs change because the spouse doesn't necessarily inherit everything. And so it's very important to think through the fact, if I die without a will, who's going to inherit? I have a current client who is well up in age, has no will at all. She was living in Europe during World War II. That tells you her age. She was a child conceived and born during the war. The father had a couple of families. She has half siblings that she hasn't seen since age 5.
Wow.
They will be her heirs if she has no will at all. I have had cases like that where if people have a will, then they can say, I leave everything to my favorite university or to my grandchild. If they have no will at all, then the state of Texas, if you're residing here, will decide who the heirs are. Typically, it's a spouse and typically children. If a child is dead, it would be grandchildren of that. There's a formula that one follows.
But it may not be at all what you intended to happen.
I will tell the story of Irma Mangels. Irma was a lady that worked for Exxon here and this is public knowledge because Irma worked for Exxon, had a very nice benefit from Exxon for having worked there. And this was a number of years ago now. But if you go to the courthouse, there is a huge file, yay thick. I'm showing about a half a foot thick in affidavits and airship documents. Irma was an orphan who was then adopted by a family in the United States. Her adopted family, you've heard of the orphan trains?
Yes.
That's a separate interesting saga in our history. Irma was adopted. She was the only adopted child of the particular family. Irma had no siblings adopted. Maybe she had natural born ones, but since she was adopted, she became legally part of the adopted family. Irma, in her 80s, I believe I remember correctly, went to a lawyer and was planning to do a will and even had a draft of a will leaving her estate to her church. That's where she wanted to go. She procrastinated, didn't sign the will, died without a will. When the court locally, Judge Hutchison was the judge, knew that I could speak and read German. This lady's adopted family were from North Germany in the Schleswig-Holstein area, which at one point had been Denmark, later became Germany, Schleswig-Holstein. This lady's adopted family were the Kalkis and the Mangels, just two families. In order to find her heirs, she had no siblings. Her parents had no siblings, her adopted parents. We had to go back to before George Washington was president of the U.S., the early 1700s, to find common ancestors. we eventually found 42, quote, heirs that split her $1 million estate.
Oh, my
42 folks. I was appointed as the attorney ad litem by the judge to help find those heirs. And it was fun. Cost a lot of money to do that. One, we found adoption and birth certificates and baptism certificates, death certificates, divorce certificates, and we eventually found 42 folks.
Amazing.
I wrote an article I thought was interesting called The Case of the Joyous Second Cousins Twice Removed. People that had never heard of this woman, hence they were joyous in that they were inheriting from someone they'd never heard of, were part of her heirs.
And never part of her intended plan.
No, of course not.
Yeah.
Had she signed the will, she would have left monies to her church, which she was close to, and I felt sorry for her, but she didn't get around to
Right.
it. And that's not unusual. A
Well,
huge,
I
huge
think
number
you've
of folks.
motivated some people today.
Well, hopefully
that,
so.
really, those are great stories and great truths. You have been not only working with one of the top firms in the world for 50
Thank
plus
you.
years. And again, we talked about your community involvement. You've been a leader. You've worked with great leaders. When you think about advice that you've gotten through the years, is there any piece of advice that stands out, from someone, either the best piece of advice or the worst advice you ever got?
Oh gosh, that could take several hours, but I think of one case, and I'll go back to when I was in grade school. I was born on a farm. We had no electricity. We had no telephones. We didn't have indoor toilets. A lady walked me to this little country school. Her name was Irene. She was the daughter of one of our neighbors. That neighbor, and his nickname was Pappy, Pappy had a brother. Pappy's brother lived in California. Probably 10 years ago, 15 years ago perhaps, Pappy's brother died in California. I still know the son of the lady who walked me to this little country school. And he said, my great uncle, whatever his name was in California, died, and they've told me about this. What should I do? They found a will that was 50 years old. The will was very, very old. It was done during World War II. And said, I really think that great uncle, whatever his name was, probably did a later will. Can you help me? We went to we checked into the California bit. There was, in fact, a will done in the 1940s, which we strongly suspected had been updated, but it wasn't there. We filed a contest of that will and eventually settled that by making an appearance in California in the surrogate court there. The basic bottom line of that story is that people should have wills, but they should update them. And if you have a will that's over 5 years old, or if you're over 10 years old, please go talk to Deborah, talk to someone like me, talk to someone and update those wills, because the likelihood is either facts have changed, your preferred beneficiaries have changed, and a will that was done in the 40s, 1940s, probably should be updated no matter what. And that's one thought.
So having a current, valid will
exactly
is
and,
really what it's about.
and a current, valid, revocable trust if that's the route you
Right.
want to go. Or double checking your beneficiary designations on your IRA or 401k or 403b or
all those mini wills. you
all the
have out
mini
there.
wills, right?
Yep.
Mini wills are important.
Well, thank you for christening the Legacy Lounge, Rod. We really appreciate it. And I look forward to the opportunity to work with you on behalf of many families.
Likewise, it's been my honor and pleasure.
Thank you, Rod.
Deborah. Thank you.
The amount of work you do on foundations and the grant work you do, I think it's 5 foundations. You're on 23 boards. Where do you find the time?
We're booked almost every evening.
In fact, you are, aren't you?
Absolutely.
You are giving back to the community. Not to mention your incredible German vocals.
You don't
Right?
really. I could sing a Czech song or a German one.
I think you must. I think you must.
Many years ago, I'll preface it with something. Many years ago, when I was a high school senior, I was the solo trumpet player in the band, and I was hired by a Czech band leader. And during some of those dances, we would sing Pivo, Pivo, Pivo Shedvene, something about drinking beer, etc. Or in German, we would say Rosamunda, frag doch nicht erst die Mama, beer barrel polka, but in German. So.
And it sounds more interesting in German and Czech, I must say. Thank you.
And
Thank
we
you.
even sang a little Spanish occasionally. Not sure I remember that these days, but any event, our life has been full of music, and I love music in Navy and any number of areas. And so at this point in my life, I am involved in probably way too many boards, but they're all fun, and they're ways to, quote, leave a legacy. So,
And you're passionate. You give so much back. You're active in many facets of the Navy, including the Battleship Texas.
which has just been refloated down in Galveston.
Exciting.
So-
Yes.
And
Well-
it's fun to be here with you. We did a lot of programs together a number of years ago when you were teaching at Rice and at a batch of the country clubs, and that was fun, and I'm so pleased you invited me back.
Thank you, Rod.